To begin with, when we talk about wills, what is really a will? A will is really speaking something which a person desires with respect to his property and the way he wants it distributed after his death. In India, we are in a situation where a person either leaves a will behind or doesn't leave a will behind. When a person leaves a will behind, it is called testamentary succession. And when a person doesn't leave a will behind, it is called intestate succession. In India, we don't have a uniform civil code. So depending upon the religion that one follows, there are separate laws which are applicable so far as people leaving wills behind and people's not leaving wills behind. Now, when people leave wills behind, the religions which get covered under the major statute, which is called the Indian Succession Act, that act applies to Hindus, Sikhs, Jains, Buddhists. Now, all these four religions I'm going to categorize as Hindus because it will become a little long otherwise if I have to keep repeating Sikhs, Jains, Buddhists along with Hindus. So they are all, I'm considering it as Hindus for the purpose of the presentation. Parsis and Christians, the Indian Succession Act applies when you make a will under these religions. For Muslims, you have the Muslim personal law as well as the Shariat Act, which becomes applicable. Now, there was a query which was raised that what if a Bori Muslim leaves a will behind, what is the law that becomes applicable? So with respect to Bori Muslims, it will be the Shariat Act which becomes applicable. And under Muslim law, no Muslim can bequeath more than 1/3 of the property till you get the consent of all the other legal heirs, which consent needs to be obtained after death of the particular Muslim who had created the will. Now, when you don't leave a will behind, what is the law that is applicable in India? So for Hindus, you have the Hindu Succession Act. For Parsis and Christians, you have the Indian Succession Act. So the Indian Succession Act not only deals with the communities that we just discussed relating to leaving behind a will, but they have separate chapters relating to Parsis and Christians when they don't leave any will behind. So far as Muslims who don't leave their will behind, the Muslim personal law becomes applicable along with the provisions of the Shariat Act. Now, it's important for me to state that if a Muslim gets married to a non-Muslim, then the Muslim law ceases to have any application, and the Indian Succession Act will apply to that Muslim if he gets married to a non-Muslim. So just to give an example, I have married a non-Muslim, and because I married a non-Muslim, the Muslim Act and the Shariat Act doesn't become applicable to me, although I practice the Muslim faith. The Indian Succession Act applies to me. Now, like I said in the beginning of my presentation, what is really a will? A will really is a desire of leaving property behind in a particular manner. Now, why do you leave a will behind? There are 2 or 3 reasons which immediately one needs to realize, because like I explained, if you don't leave a will behind, then there are particular legislations that the parliament has created in India where the succession will have to be followed in the manner that the law provides. Now, if you don't want to follow that particular law, it is important that you leave a will behind, so then whatever your desires are and you want the property distributed, it goes in the manner that your will sets it out. Now, just to give you an example, suppose a Hindu doesn't leave a will behind and he wants his property to go to his father. If a Hindu doesn't leave a will behind, under the Hindu Succession Act, the property of a deceased Hindu goes to his spouse, his children, and his mother. It doesn't go to his father as the class 1 heir. But if he wants to leave a property to his father, and if he does not create a will, unfortunately, if he has his mother or his spouse or his children alive, they are going to completely overrule father's bequest. Their father won't be entitled to any property and it will go only as per the law in the manner that is indicated. So you leave a will behind because you want your relatives to get particular properties of yours. You want that your intention needs to be documented. You want that this document of yours needs to be given effect to after your death. And there are certain other reasons why you would leave a will behind. There may be certain charities that you may want to create after your death, which the legislation does not give you any such kind of benefit. There may be certain other people who are not related to you, certain friends, certain employees, certain other people who you have become very fond of during your lifetime, and all those people would not form part of your legatees as per the legislation unless you leave a will behind. So that is why a will is required when you want to provide for whoever in your lifetime has given you any such kind of satisfaction, or your companionship, or somebody who you trust, you love, and you want to leave behind, who don't really belong to any part of your kindred or not your relative. That is what a real will is. Now, who can make a will? A will can be made by any person who has attained the age of 18. The requirement is that that person needs to be of sound mind. He shouldn't face any kind of insanity issues. Even if a person is deaf, dumb, or blind, he is entitled to make a will. He needs to be completely conscious of what is he really doing. And that is the only, these are the only things that need to be, looked into when a person is desirous of making a will. Of course, you will make a will only when you have something to leave behind. So we will come to that a little later. But as long as you fulfill these three criteria, that you're a major by age, you are of sound mind, and you're conscious and you're aware of what you're really preparing. You know that this is really going to be your document which you are going to leave behind for whoever you want to leave behind after your death. It's good enough for you to call it a will. Who cannot make a will? A minor cannot make a will. So any person who's not attained the age of 18 years of age, that is under the Indian Majority Act, he's considered as a minor. So a person below 18 cannot make a will. A person who is of insane mind, or he has bouts of insanity. Now here there is something very interesting which our law actually allows. So if a person is ordinarily insane, but he in fact is able to comprehend, and the doctors say that at particular moments he is, he has sanity of a normal person. During those moments of sanity, he's able to prepare a will. That is what the Indian Succession Act actually allows. But ordinarily, if a person is insane, he is not allowed to make a will because he doesn't know the consequences of his action. And the government and the law actually protect such people so that they don't give away their properties without realizing the consequence of their actions. Likewise, a person whose mental state is not not able to comprehend what they are really doing, such kind of people also cannot make a will. It goes hand in hand with an insane person. Now, what are the advantages of making a will? The advantages of making a will is that firstly, it sets out exactly how you want your property distributed. It identifies in certain cases as to who is the person who's going to be responsible to carry out your desires, and who are your beneficiaries, also your legatees, and the properties that you're going to leave behind, in the manner that you're going to leave behind, and how you're going to leave behind. So the will actually sets out who gets what and in which manner. So this is the advantage of making a will, because this exactly sets out how you want your properties distributed after you are no more. You can, like I said earlier, when you make a will, except when you're a Muslim, you can actually bequeath your property to even somebody who's not related to you. You can provide for certain of your relatives to get, properties under your will. You can exclude certain other family members. You can provide that these are the reasons that I don't want to leave anything for such of my family members because I have not been treated properly. I have not been happy with our relations. So you are able to set out specifically those who you want your properties to go to, and those who you want to exclude completely, who would have otherwise, in the absence of a will, been able to bequeath your property, although your relations were strained and although you all never really got along while the person was alive. So this advantage of making a will is you can leave your properties exactly to the people who you want your properties to go to after your death. Now, what is it that should be contained in a will? Now, very normally, as anybody would understand, you need to give your personal details. Your personal details would include your name, your age, your address, your religion is important, because depending upon which religion you belong to, even in case of leaving a will, the law would become applicable. You should set out who all comprise your immediate family. You should set out the date of you making the will. You should also set out whether this is your last will, or if you have made any previous wills, you should provide that you are revoking all your previous wills, along with giving dates as to when those wills were made, and say very specifically that this will that I'm making as on this date is my last will and I'm revoking all previous wills. You need to also provide that you are of good health, you are of sound disposing capacity, and you're making this will out of your own free mind without any kind of pressure, any other coercion, or any other, which would somehow undermine the free mind of yours to prepare what you call your will. So these are the things that need to ordinarily be contained in a will for it to be complete in all respects. Excuse me. Now, what all should you contain in your will? One, you need to provide for a responsible person who will be called as an executor, who you will identify, who you trust completely, and who you're giving the responsibility for the purposes of distributing the properties in the manner that your will contains. Now, I must say that it is not absolutely necessary to appoint an executor. However, it is recommended that you appoint an executor because you don't want your legal heirs to fight amongst themselves when you have bequeathed unequally to people who are, left behind in terms of your legatees. So it is always recommended that you have a third party who you trust, who you think is going to be responsible, who your legatees and beneficiaries will look up to and obey. And that person should be given the responsibility of carrying out the distribution of the property, applying for probate, and to do whatever acts you actually impose under your will to be carried out by him. So first you should try and have an executor appointed. You should set out all your properties in your will, including any share that you hold in any Hindu undivided family property. Now, this concept of HUF, which is Hindu undivided family, it's applicable only for Hindus. No other religion has this benefit, which is available to Hindus, called the Hindu undivided family. Hindu undivided family comprises all your relatives, starting from your great grandfather and going down 4 degrees. That is your great grandfather. After that's your grandfather. Then it's your father. Then your son. From when you go in the ascending order, and when you go in the descending order, it will be your son, your grandson, and your great grandson, and then your great grandson. Now, what you can include apart from your self-owned movable and immovable properties, you can also include any share that you have in HUF property as a kopasna. Now, what is a kopasna? In every Hindu undivided family, we have something called as a family member, and we have something called as a kopasna. Now, a kopasna is initially, under Hindu law, a daughter was not allowed to be called a Kopasna, and only the rights of a Kopasna vested with the male in the family. Now, the advantage of being a Kopasna is that you would be entitled to partition the HUF property and demand your share. Now, this law about only sons being Kopasnas under the Hindu Succession Act was amended in the year 2005, where the parliament actually gave daughters an equal right as that which a son enjoyed. So in 2005, there was an amendment to the Hindu Succession Act, which categorized and which entitled a daughter in an HUF to also be a Kopasna. So she was no longer only a family member, she was also a Kopasna. Now, whether she was married, unmarried, it didn't matter. She was a Kopasna as long as the father in the family was alive. She had a right in 2005. The cutoff date was 9 September 2005, which entitled her to demand a partition as long as the father was alive. Now, in 2020, there's a judgment which has recently been passed by the Supreme Court in the matter of Vinita Sharma versus Rakesh Sharma. This was a query which was asked by one gentleman in the list of queries that I saw. This recent judgment of the Supreme Court actually enlarges the right of a Hindu daughter to not only 9th September 2005, but also entitles her to properties before 9 September 2005, and even though the father is not alive. So the law which the parliament came out on 9 September 2005, the 2005 amendment, it entitled a daughter to be a Kopasna as long as the father was alive. Now, the Supreme Court judgment in respect of this law says that the daughter doesn't need to get this right only from 9 September 2005. She gets the right from her birth. And even if the father is not alive, she will get this right. So this amendment which was carried or which came into force in 2005 has been given a retrospective application by virtue of a judgment of the Supreme Court, which has been passed in this very month in August 2020. And the name of the case is Vinita Sharma versus Rakesh Sharma. I'm going into the specifics because of a query that was raised about this judgment, and I thought that this would be the right time and place to mention about this judgment. What your will should also contain is that it should set out unambiguously as to which property goes to which beneficiary. So without any complication, without any interpretation, as long as the identity of the property is very clear, you need to set out as to which of your property goes to whom, and there shouldn't be any confusion either in the mind of the executor or by the court. I'm saying court because there could be a dispute relating to the will after it is challenged by somebody. So you need to look at it from that perspective, that things that would ordinarily be clear to you may not be clear to a third party who has to look into your will, sit into your shoes, and then decide as to what you really intended. So that is why you need to ensure that when you leave any property behind, you provide specifically and identify it so clearly that there is no ambiguity as to what is that property and who that property needs to go to. If you're excluding certain of your relatives from your will, you need to set out the reasons why you are excluding it. It is going to be very natural for those people who you have not left behind to challenge the will. They will say that you are coerced, you are under some influence, you are not of your right senses, and that is why you wouldn't have prepared this will if you were in your right senses, and they will challenge you the will. In order to avoid that situation, you need to very clearly provide why you are excluding your relatives, your legatees, what is the reason. You should also try and leave a residuary clause behind, because it's possible that after you have made a will, there could be other properties that you may have acquired. It's possible that you may have not dealt with all your properties. We don't want a situation that there's a vacuum. What happens to those properties? So you should provide a residuary clause saying that if there's any other property which I have not covered in my will, all those properties go to so and so person. So it's important to have a residuary clause for this reason. Lastly, the will needs to be signed. It's a very important rule for a will that you need to not only sign it, but you need to have your will witnessed by two witnesses. This is the very important condition, that unless a will is witnessed by two witnesses, it is not considered as a valid will. So when a person wants to prepare a will, ideally he should identify two witnesses. Those witnesses ordinarily should not be people you're leaving any bequest behind. The law says that if you leave a bequest behind to any of your witnesses, the bequest will be declared as void. So please identify two independent witnesses who are not your beneficiaries, who you're not leaving any part of your estate behind, and please ensure that you execute your will and the witnesses execute, attest the will and sign as witnesses in your presence.